Please, Lordship. Lordship, I beg to mention this item number 19, Your Lordship. I have informed to the GHTC. No, 9, Lordship. I'm sorry. 9. Not 19, 9.
If you have your own cause list, we don't know.
I have. Yes. I pray this matter may come after 2 weeks, my Lord.
That's connected to 8.
Yes, Your Lord.
Okay, we are passing judgment very soon. The other one also.
The market regulation.
Yeah. Okay, after 2 weeks. No objection, Mr. Jindal. You're not there in the case.
Both 8 and 9.
Correct. Yes.
That's right, Lordship.
Item number 1. Item number 1.
Lordship, if I may, Lordship. I beg to mention item number 11, Lordship. This income tax matter, Lordship. Any petition?
Why is Mr. Thanda pushing you?
Lordship, Lordship, I am from the respondent.
Oh.
Lordship, what has happened is that London Senior Counsel, Mr. Ezekiel, will be here on 5th, and all the income tax matters are fixed on that day, Lordship. I pray that matter may come on the 5th, Lordship.
Yes.
5th August.
5th is when?
5th August, Lordship. 5th is on Tuesday.
Tuesday, Lordship.
You agreeable?
Lordship.
Yes.
Hello, Lordship.
What's the matter about?
Income tax.
1026.
1026, Lordship.
Item number 1.
We are respondent number 1.
You entering a parent's on behalf of the
Well, it's respondent, well, it's sole respondent.
correspondent.
That's
Yes.
it's the only issue here, well, it's the issue of maintainability of this appeal before my lords. Well, we are saying that this appeal is not maintainable.
Why?
Well, A, it is time barred. B, in paragraph 6, the issues that they've raised pertain to questions of law. Now, what has been provided in paragraph 6 essentially do not constitute any questions of law.
But that have to be a matter of argument.
That's as your lordships may fit. But the issue of limitation would be because they are required to file this appeal within 4 months. There is no condemnation of delay.
4 months.
It's way beyond millets. The impugned order is dated 14/8/2024.
Page?
Millets, my lords would find it at page 22, Annexure C.
That's correct, Mr. Pandey.
Lordship,
My lords, may kindly have a look. Date of pronouncement is 14/8/2024. If I may draw your lordship's attention to page 29, that's the last page of the memo of appeal, my lords. At serial number 3, my lords, the copy has been given to PR CIT Shillong. Now, if I may draw your lordship's attention to section 260 capital A. Subsection 2, my lords. My lords have section 260 capital A, lords.
Yes.
Well, it's an appeal shall lie to the High Court from every order passed by the appellate tribunal before the date of establishment of so-and-so, if the High Court is satisfied that the case involves a substantial question of law. Number 2, my lords, the so-and-so or Chief Commissioner or the so-and-so or an SSE aggrieved by an order passed by the appellate tribunal may file an appeal to the High Court, and such an appeal under this subsection shall be filed within 120 days from the date on which the order appealed against or so-and-so, so-and-so
Yes, it
is
received by
received.
the principal
My
commissioner.
lords.
So, Mr. Pandey, what is your submission
Lordship,
on the question? How many days then, by your estimate, will the appeal be barred?
331 days. Well, our calculation is barred by 331 days, my lords.
Lordship, I humbly pray that this matter also let it come on the 5th, Lordship. I'll satisfy my lords. Mr. Kyle also will be there, Lordship.
Okay, we record Mr. K. Paul in senior counsel with so-and-so as his appearance on behalf of respondent to the service complete. Stop. Next part, Mr. K. Paul, the little senior counsel on behalf of the respondent has raised two questions. Firstly, on the question of limitation, and secondly, on the maintainability of the appeal itself, on the ground that there are no questions of law to be decided in the instant appeal. Stop. However, list the matter then for admission hearing.
That's clear.
Most of it.
I'll leave that.
Item number 2.
Is your lordships.
1 second.
Lordships, I am appealing on behalf of the petitioners, my lord.
Yes.
And we are supposed to file a rejoinder affidavit, my lord. Otherwise, the affidavit is ready. But the petition is on way for filing this affidavit. It should not come, my lord.
Those for the respondent. Mr. Pandey, who's the President of India?
My lord, I am appealing from the department responsible for lordship.
Okay.
Lordship has fixed up for filing hearing commencing September. You will then they may file their reply.
Yes, Mr. K. Chowdhury, Learned Counsel for the petitioner, prays that be allowed further time to file the joinder affidavit. Stop. Mr. Chetia, for respondents, answering response 2 to 4, prays that the matter, if submits the matter, can be listed for hearing in the meantime. When you want it? What is the matter? September. Now we're sitting in July. Just after 6 weeks, okay. For hearing.
Item number 3.
My lord, there is an application move by the appellants, my lord, seeking leave to appeal, my lord, to file an appeal, my lord. Now this appeal has been preferred not by the complainant, claiming the appellant claims that she is the sister of the victim, my lord. Now there is no legal heirship certificate attached with this, and she also claims that the complainant died, and there is nothing to substantiate this, my lord. Therefore, my lord, allow me to file objection to this application, my lord. There are 2-3 legal questions I want to raise also. Another question is that they have invoked the provision of CRPC. Now, whether the appeal is a continuation of the trial, that needs to be also, my lord, that needs to be also argued, my lord. 2 weeks time, my lord, kindly allow me.
The sister is a victim. She was the
sister of the
alleged to be have been
victim
murdered.
and daughter of the complainant, my lord. Original complainant.
Legal aid matter.
Legally, of course, it's a legal aid matter,
Under
my
very severe compelling circumstances.
my lord.
Yes, Mr. Miss Case 35, 2025. Mr. P. Win, appearing for the respondent one, prays that I'm allowed to file objection to the application for leave to appeal. With objection, yes, prays allowed this after 2 weeks.
2 weeks time, my lord. Obliged.
Item number 4.
Wait, please, your lordships. I'm praying for some more time this matter, lordship.
What is the matter about?
No objection.
What's the matter about?
Well, refund claim.
Refund of GST?
Yes, refund. Interest, refund of interest.
Interest.
Yeah.
Yes, How many times has time been given for affidavit?
This will be the fifth time, Lordship. Lordship.
time?
Yes, Lordship. Lordship, as we've received instruction from respondent number 1 to 3, but we're still awaiting instructions from respondent 4. Therefore, we require some more time, Lordship.
Ms. Kang submits that no instructions have been received from the respondent 1 to 3. Further instructions are awaited from respondent 4 to enable them to file a complete affidavit. It's from Guwahati only. Yes, it is noted this matter has been filed since February 2025. And the affidavit is yet to be on board. So, however, next paragraph, in interest of justice, further 3 weeks' time is granted. It's expected the next day the affidavit should be on board. Yes, it's posted on so and so.
Item number 5.
Lincoln BB. Is Dr. Mujika Available?
Available, Lordship. He's on his way, Lordship.
Why do we adjourn it?
My lord, I have submitted the authorities.
Your Lordship, in that case, I may pray that some time may be given, Your Lordship, so that in order to go through the...
Examine.
Yes, Your Lordship.
You can file your bullet points in the meanwhile and we'll generate the judgment. Because the only questions of onus, correct? That you see that the burden, you see the burden's not upon you.
Question of law.
While question of
Question
law.
of law and perversity.
While you see that the burden's upon you too. Another thing is that you say they are not considered material evidence.
Yes, my lord. I'll show my lord at the time of argument.
You want to argue it?
Not today.
On the next day, Your Lordship.
We are dragging this matter unnecessarily, you know. Yes, Mr. Das Gupta has submitted a compilation of authorities to be relied upon in the matter. Stop. Copies of the same also been made over to the counsel for the appellant or for the respondent. Ms. R. Gurung appearing for the respondent prays that you will have some time to examine the compilation. List after 2 weeks or 1 week for final arguments.
2 weeks, okay.
2 weeks, yes.
Much obliged, Lordship.
Much obliged.
What happened to that? Oh, no, come on, adjourn.
Any mention?
I will please, Your Lordship.
Yes.
Your Lordship, I beg to make a mention for item number 10, Your Lordship.
Number?
Number 10, Your Lordship. I'm appearing on behalf of respondent number 6, the State of West Bengal, Your Lordship.
Number 10 has been repeatedly. Which one's number 10 is?
Bella Kishan, Your Lordship.
Bella Kishan.
Yes, Your Lordship.
What is your name?
Emling.
Who's appearing? Mr. Is it,
The local council is only for Your Lordship because due to some bereavement.
you are appearing from where? SP Sharma.
I'm appearing from Your Lordship.
You're the arguing counsel.
Lordship, I'm not the arguing counsel.
Who's arguing counsel?
Mr. P.K. Tiwari, Your Lordship.
You have any objections to adjournment?
Lordship, on multiple occasions they have been seeking adjournment, Lordship, even in the order dated 29/5.
No, today, I'm saying today they have some person. What difficulty do you have?
Actually, my senior is still on legs before the Honorable Supreme Court, Your Lordship.
Lordship, my only submission will be that in the next date fixed, no further adjournment may be allowed, Lordship.
On the next day, we will finish it, Your Lordship, without way. Your Lordship, if the matter can be listed on 2nd of September, Your Lordship.
Who's your senior?
BTAP, Your Lordship. He's the AG of Mizoram. Senior Counsel BTAP.
And we can't make adjournment like that. You better argue it yourself. I think you're competent enough.
Your Lordship, that is the instructions, Your Lordship, that I have received.
We can't give a date, yes. We listed in the first week of September then.
Oblige, Your Lordship.
2nd of September.
First week, yeah. We take a date, yeah.
Yes, Your Lordship. Oblige, Your Lordship.
Please, Lordship. Lordship, I beg to mention a matter. If we can be referred to the mediation drive, parties are
Which one?
This is WPC 459 of 2024, Lordship.
459.
My Lord, this matter was in the list of the matter referred to the
Item
mediation.
number?
I have objected on the last occasion. Not today, my Lord. Yeah, on Friday, my Lord.
It was there on Friday.
And I have objected, but my Lord, they have requested Senior Counsel Mr. Andy Shulai, my Lord. So if they wanted to, so my Lord, we will not object if they wanted to take a try, my
referred
Lord.
to the mediation drive.
Give the mention,
I'll
ma'am.
I'll submit the mention. Published.
Yes.
Yes, my lord. My lord, I'm mentioning an urgent listing, my lord, today. I am appearing on behalf, this is a writ petition, my lord, appearing on behalf of the Limokra Sports Social and Cultural Club against the Shillong Sports Association at Polo. There was a match held under the tournament is the Under 24 Division Football League cum Knockout Tournament 2025. Now, my lord, there was a match between me and the Gulf Link Sports Club, wherein I scored 4 goals and 3 goals. We won. Now these points were arbitrarily removed. The reason being because, my lord, that I had ineligible players. So we accepted this penalty of removing my goals. However, when the same match, there was a match against Lad Ulong Sports Club, and they brought in eligible players, my lord. Their scores remain intact. Now, because of that, my lord, I became ineligible to take part in the quarterfinals, and that is the reason there's urgent mentioning and the urgent listing of this matter, my lord. If I do not take part in the quarterfinals tomorrow, my lord, then these young children, Lord Jesus, Lord, I'm sorry, my lord.
How do you expect this court to examine that today if the quarterfinals are tomorrow?
Because
there's no other appeal before the Meghalaya Football Association.
No, my lord, they arbitrarily remove my scores. That is the reason.
That is totally in sports. How were the fundamental rights? How are fundamental rights affected?
My lord, if these rules were not followed, if you remove my scores because I brought ineligible players, then you should also remove other players' scores also, the other team scores also. Then it can't be that only I should be penalized, no, my lord.
You want it today?
Yes, my lord.
Let's see the petition. Have you filed it?
It's in the process of filing, my lord. This is a rough, my lord. It's a little.
When was the last match held?
The next match is to be held tomorrow.
You were disqualified, where your points were taken away.
I'll tell you, my lord. it was held sometime in the 28th, my lord.
6, then now this other
No,
match was held when?
27, my lord, 28.
And the other match was held when, where you said that?
The next quarterfinals will be held on the 7th.
No, where you said that in like Oolong, it was held on?
Well, I don't have the copy right now with me, that's the reason.
Okay, we'll allow your mentioning, but I don't think you'll get any relief here.
What?
There's a system in place, I think. Yes.
I'm surprised, my lord.
Mr. Lordship, I beg to mention item 16. Lordship, the petitioner had already filed that additional affidavit. This is that matter that Tlongpling village, Tlongpling, that the Maharam and Bhawal matter. So I'm for district council. They have filed their affidavit yesterday, so I need to study the affidavit because I've translated.
No, it's an affidavit to bring on record, Your Lordship.
We have not received the copy.
Okay, but it's after 2 weeks.
2 weeks, Lordship. Pleasure.
May I please, Your Lordship? I beg.
Of the district council respondent, yes?
No, Your Lordship, I have no objection.
Yes.
2 weeks.
Yes.
Pleasure.
I beg to mention item number 11, Your Lordship.
Very grand moment.
Yes, I'm praying for.
On behalf of respondent number 3, Your Lordship.
I'm praying for 2 weeks' time, Your Lordship.
Why?
Some butthurt matter is there, Your Lordship.
You're there, a matter? Yes.
Much advice, Your Lordship.
Please, Your Lordship, I'd like to mention item number 12.
Number?
12. Can you have this matter after 2 weeks, Your Lordship?
Why?
Personal difficulty, Your
What's the
Lordship.
matter about?
Promotion, Your Lordship.
Motion.
Don't adjourn just for the sake of adjournment, huh? Okay.
Pleasure, Your Lordship.
May it please Your Lordship, I beg to mention item number 14. I prayed for 2 weeks' times, my lord.
Lordship, I'm appearing for UGC in this matter.
You have objection?
Objection, Your
No
Lordship.
objection. Why are you on adjournment?
The senior counsels have some personal difficulties.
Do you know that this petitioner has made complaints to the court regarding the repeated adjournments taken by his counsels? You're aware of that?
No, Your Lordship.
That's why the counsel will change also. Yes, mention against made on behalf of the petitioner for adjournment.
Similar period for
Not objected
item
to.
number.
We're not finished dictating this. Then still not objected to by the counsel to respond. It's up to 2 weeks. Yes.
Similar period for item number 18, Your Lordship.
Yes. Who's the other side? Dr. M. Muzika. Yes.
No objection, Lordship.
Yes.
Much obliged, Your Lordship.
Supplementary list item number 1.
May please, Lordship. Lordship, this is I'm challenging against the illegal approval of the video, the approval of the VSC functionaries. Now, what happened? The VSC functionary prior to expiry of the date of the term, they have resigned. Then, after the resignation of the previous VSC functionary of Raspur Muslim VSC, they, without any election, they have recommended the name to the video, and video have just approved. Actually, there is a notification. There is
Are you saying your terms are subsisting?
Term is already expired. Then after when the time is expired, they're supposed to hold a fresh election. Instead of holding the fresh election without conducting any election, they have just select the name of these private respondents and forwarded to the video, and video have just approved it.
Where's that?
Yes, yes.
VC.
Lordship.
Let's see, where's that?
Yes, that is challenging this particular.
Yes, where? Where's that approval?
That is page 26.
Page?
Annexure, page 26, annexure 5, my lord. It is clearly mentioned. May I just read it in pursuance to the Gram Sabha here in.
So there was election.
No, they said it's a selection.
Yes, as new committee on consensus by hand raised as demanded by the job card holder of Rajpur Muslim VEC.
Selected. selected. So
what does the rule say?
The rule says, my lord,
Selection or selection?
It's an election.
See, take it out. Where is it?
Yes, notification, the page 19, and then also the page 21.
No, see the. Is this legible?
Another page 19 is a type copy, my lord.
Where is the election?
Yes, this is notification. The
yes.
Read the closest sentence, sir. May I just read in the said notification that 1, 2, 3, that one is against the para 7A clause 4. The sentence: there shall be 3 elected members, each VSC including traditional headman and female member, so represented VSC at AEC will be replaced, which each VSC will have a program executive implementation committee to implement the scheme in the village. This committee will comprise of 5% conversant with the NRGS Meghalaya, out of whom a chairman and secretary will be elected. Chairman, secretary and 1 woman member will represent VSC AEC level. This committee will be decided by general body meeting of VSC. Against para 7A clause 5, the section will read as: meeting of VSC will be chaired by the chairman of program executive committee, village headman, traditional village head and secretary for VSC may be elected by the member of VSC from among the members. Against the para 7B clause 3, the 3 elected member will be consist of 1 female, 1 male. The village traditional headman, Nokma of the village will be deleted. It should be elected, and it will now reward as 3 elected members will be consist of 1 female chairman.
The impugn order again.
The impugn
Annexure 5.
Yes, Annexure 5.
When is it dated?
It is dated 10th December 2024. Is that in pursuance to Gram Sabha?
To read it
here.
Why not you read it? Why you have come now?
Earlier we have filed a case that previous VSC was there. Then after a while the case was pending, Lordship. This notification, this impugn order, they have enclosed it because this since I have not made a party to this instant private respondent, therefore we have withdrawn and we have filed a press.
May it please your lordship. Your lordship, the first round of litigation was filed on 11 of February 2025, lordship. The lordship, the state filed its affidavit on 13 June 2025. Immediately on filing of affidavit, lordship, they took the liberty to withdraw the instant case from this honorable court on the plea that there are other developments. Now, lordship, the present writ filed before this honorable court, there are no developments at all, lordship.
No. Is this VC by selection or by election?
It's by the selection, lordship.
No. What does the scheme provide?
Lordship.
By election or by selection?
The scheme, lordship, provides. But it's valid till 2027, my lord.
No. By selection or by election?
My lord, I'll just take a lordship to the notification, lordship.
And whether raising of hands will amount to election or is it selection?
Actually, practically, there should be they should proper to conduct a proper.
Where does it say?
Yes, sir, the page 21, Annexure 2 is there.
The election of the VEC shall be by way of secret paper ballot or by any manner prescribed. Now, elections can be by raising of hands also.
However, yes, but that should not be selected. Whatever, that should be an election.
What? Selected means there is no election.
There is no election.
You are selected by maybe a BDO or by some other few members, and your names are put up and said that Mr. P.T. Sangma and so will be the. So that is selection.
Yes, selection.
Election can be by raising of hands also.
Yes.
Now, what does the scheme provide? What does it say? Because according to this impugn order is by raising of hands. Which you say is selection.
Selected. There should be an election, my lord.
That's an election
Yes.
also.
Yes, raising hand can be election, but there is no election. My contention is there was no
What is the
election.
definition of election?
Election means
Will it
that
necessarily be
there will be a
that
candidate.
Election will be by now even the bar session before you have election when there was not much discord. Elections were okay, fine. Mr. A for president, Mr. B, who supports him? Then they raise hands. The hands counted. Who supports Mr. B is counted. Yes. And so if Mr. B wins and Mr. B is declared elected by a vote of, by voice vote they call it, by raising of hands, correct?
Yes. But here rule prescribe, but they did not
prescribe election. But
election.
What
the manner, the specific,
only by secret ballot.
That the mode of election they don't prescribe. I mean, it's like there should be a candidate.
So other elections we see how's it done.
Other election BSc, my lord, in the previous they used to nomination paper will be there. After the nomination day is there, the second ballot will be there, and after that election
he functions the returning officer.
Yes, there is a returning officer is the BDO himself.
Let's see that.
We have seen in the
last
other
elections. Have you annexed?
The last election on the previous one, I did not enclose it, but it is there, lordship. I can put it in the additional affidavit.
So you take instructions.
Yes.
Heard Mr. P.T. Samman, Learned Counsel issue notice. MS NG Shilla is present except on behalf of the respondents 1 to 4. Notice to go to the respondents, the remaining respondent within 3 days. Stop. The grievance of the writ petitioner is that there was no election for the current VEC. But that the same was approved merely on by selection on a consensus by hand raising. Stop. Next paragraph, MSNG have to obtain instructions as to the exact method of election or selection and as to whether the mode of election is prescribed just after 2 weeks. Yes.
Lordship. Most press, lordship.
Item number 2.
May I please say, Lordship? Lordship, challenge the election of Ambari VC, my lord.
Same matter?
No, my lord. It's a different, my lord. Ambari VC, my lord. On 3 grounds, my lord. Most arbitrarily, my lord. First, they have conducted the job card verification, my lord. That is under job card verification on 18 June, my lord.
When were the elections held?
Held on 18 July, my lord. Job card verification was conducted white notification dated 18 June and conducted on 19 and 20 June. And job card, total 98 job cards, my lord. In is a small place, my lord. 98 job card holders are strongly participated in the verification process. And after verification, no cancellation, no outcome was issued or intimated from the office of the respondent number 5. Then, my lord, on 7/7/2025, the respondent number 5 had issued notification whereby the election will be conducted on 18/7/2025, my lord. My lord, now interestingly, my lord, on 17 night, my lord, 17/7 at midnight, they have published and circulated a list, my lord.
At midnight?
At midnight, my lord. After around 12, my lord. Kindly have, my lord, page 30, my lord, Annexus 6. This is the eligible voter list for Ambari VEC, my lord. In this list, my lord, kindly see the next page 33, 84, my lord.
Yes, out of 96.
Out of 96. Now the next page, my lord, Annexus 7 is the annexure of this, my lord.
Yes.
Total 14 job cards
have been struck off.
Cancelled, my lord. Without intimating, without issuing any notice, without intimating to the job card holders at the midnight, my lord, on 17, my lord. When the petitioner, along with the supporters, on the next day morning, they circulated in the official, in the WhatsApp as well as in their official websites the petitioners received in the WhatsApp. On the morning, my lord, when election held, my lord, on the 18th, my lord, they raised the objection. They want to file a petition to the concerned officers, but they refuse. And thereafter, my lord, the petitioner was thrown out from the center, my lord. And
Who's the petitioner?
My lord, petitioner is the second
rejected
candidate, my lord. One of the candidate
Hasina Khatun.
Candidate for
the a disqualified voter.
No, my lord. She is the candidate who participated.
How many votes?
She after the election held, she secured 16 votes, my lord. And petitioner, the respondent number 6, the winning candidate, she secured 50 votes, my lord.
50 votes. So
and now,
you got only 16 votes.
My lord, I'll come to that, my lord. My lord, out of 98 votes, out of 98 total votes, 14 were cancelled, my lord. Now 18 voters were not participated in the election due to the confrontation in the morning, my lord. And the petitioner was thrown out from the election center, and she was not allowed to provide his as an election agent during the election process, my lord. That is the second condition, my lord. Now come to the, my lord, notification, my lord, which
Mr. Hassan,
is, my lord,
my own submission that the petitioner only 16 votes.
Yes, my lord.
Even if these people whose votes were rights were cancelled.
Yes, my lord.
There are 14, we got only 40 votes.
No, my lord, another
and 18. Got 50 votes, the other one.
My lord, yes, my lord. Another 18 votes were not participated due to the quarrel in the election process. My lord, 18 votes were not polled, my lord. Because, my lord, kindly see page 27, annexure 4, my lord. The notification.
You've seen the reasons they've given for why your name's been struck off.
My lord.
You've seen page 30 for the reasons?
Yes, reasons were there, my lord. They have given.
Reasons correct or wrong?
My lord, these reasons were wrong, my lord. As per the Manrega.
Same kitchen with son.
My lord, yes, my lord. As per
same kitchen with mother.
No, my lord. As per the Manrega Act, my lord. Manrega Act, my lord.
Sharing same kitchen is not a ground.
No, my lord. I can show the act, my lord, in the act itself, my lord. But my lord, kindly see page 27, my lord. Yes. They are violating their own guidelines, my lord. Page 27, annexure 4, my lord.
Yes.
My lord, kindly para 8, my lord.
Yes.
Each candidate will be allowed one person as polling agent and counting agent inside the hall, my lord. Now,
the procedure has been given.
Yes, my lord. Under that A, my lord, election will be in a democratic way. Recent MIS data base of Ambari VC will be used as an electoral roll, my lord. This notification comes after verification, my lord. This notification after verification. Now MIS data I have annexed, my lord. In the MIS data, my lord, the voter which were cancelled, my lord, 14 votes were there in the MIS data, my lord. Now they are violating, my lord.
Where's MIS data?
My lord, at annexure, my lord. At annexure 10, page 41 starts from, my lord. This is the complete MIS data, my lord.
For Ambari?
Ambari, my lord. We have downloaded from the website from the Batabari VC block, CNRD block, my lord. My lord, because the entire process was marked by, my lord, unfair practice, my lord.
So you mean to say that the removal of the names was to favor the other?
Number one, my lord, at midnight they have cancelled. Second, my lord, when confronted with raised the objection, petitioner was thrown out along with the supporter, and she was not allowed to provide her election agent as per the notification in the election, my lord.
Yes.
And 18 votes were not participated due to the confrontation, my lord.
May it please your lordship. Your lordship, at annexure 7, the remarks given here are genuine because the elections were conducted in a very free and fair way, lordship. My lord, the allegation with regard to the other 18, lordship, being thrown out, that is, I think, mostly on presumption, lordship. But even then, lordship, majority of the voters have voted, lordship, for the winning candidate, and the results have already been declared, lordship. The losing candidate is just a case of sour grapes, lordship, nothing else.
My lord, the total
it's been dramatized into a Hindi serial.
66 votes were polled out of 98, my lord. 14 were cancelled at midnight, and 18 were because of this issue cancellation of 14 job cards on the morning.
So 32 votes didn't come. Then 32 votes were
washed out, my lord. And my lord, the entire process, because my agent
32 plus 16, that means you would have how much?
32 plus 16 will be, my lord, 48, my lord, because my lord,
still lost election.
my lord, because the fair man, because my agent was not there, my lord, they will not allow my, because I raised the objection.
Notice, let them file affidavit.
My lord, I like to submit one, my lord, order. My lord has passed, my lord. Kindly, my lord, have a look, my lord, kindly. My lord, in the similar situation, proxy votes and dual voters, my lord, senior advocate Mr.
votes.
My lord, in the other matter, my lord, the Rubika CH Marak WPC number 429, my lord, kindly have, my lord, the para 7, my lord.
Yes.
On hearing the learned senior counsel and on examining the materials, a prima facie case has been made out for some interim orders. Inasmuch as it is seen that the certain voters who have shifted their residence as per the job cards which have been annexed to the writ petition, which clearly shows that they were not eligible to vote for Namabila, but however as submitted have been allowed to cast their votes. As it has been reported, the elections have been held on 13/11/2024. It is provided that the result of the same will be suspended and the BDO respondent number 5 is directed to look after the affairs of the said village until the next day. My lord, at least, my lord, at this time. Now, otherwise, my writ petition become infructuous, my lord.
See, the very fact that, see, your dispute is to the 18 who were disqualified. Correct?
14
who were disqualified, plus 18 who did not vote.
Yes, my lord.
Correct.
Correct.
And your prayer is that there should be 98 voters in all.
My lord, as per the MIS list.
MIS.
Right?
So now you said 50 voted in favor of the respondent.
Yes, my lord. Correct.
So 48 is other votes.
My lord, they are
taking to account the people who voted for 16.
My lord,
taking account the people who did not vote. Maybe they won't vote for you also.
My lord has to appreciate, my lord, the notification.
We appreciate everything, but no interim orders.
My lord,
let them.
My lord, my petition will become infructuous if the approval order will be issued, my lord.
See, Mr. Hassan, we would have issued interim orders if the case lies in the balance. Because now it's only a sort of inquiry as to whether those people who valid job card holders have been rightly deprived the right to vote. That's all.
My lord, kindly, my lord, at least, my lord, until the next returnable date, my lord.
Yes, Commissioner, you should notice Ms. NG Shilla's present access notice on behalf of respondents 1 to 5. Notice to could remain respondents within 3 days. Stop grievance of the writ petitioner as projected is with the disqualification of 14 job card holders from participating in the elections to which Ambari PEC West Garo Hills stopped. It is submitted by Mr. S.K. Hassan that after the verification of job card holders in the night preceding the elections, the final list of valid job card holders was released, amounting to 84, and 14 job card holders were declared ineligible to vote.
Ineligible.
He submits that this has materially affected the elections, and as much as further 18 voters also did not participate.
Yes, ma'am.
Therefore, prays that in the interim, the election results not be given
suspended, my lord.
Next, Ms. NG Shilla, Senior Government Advocate, in reply submitted that the reasons given for declaring the 14 voters as eligible are valid and have been recorded in the remarks of the respondent 5. Further, she submits that even if all these voters had cast their votes in favor of the petitioner, the results would still not be affected.
My lord,
it would not be affected. And I thought she prays no interim orders are called for at this stage. So, counsel for the parties examining the materials as placed, is seen that as submitted by Mr. S. Hassan, the winning candidate, that is respondent number
6, my lord.
6 had secured 50 votes, whereas 16 votes have been polled in favor of the petitioner. even taking consideration the fact that the remaining voters would have cast their votes in favor of the petitioner, it is not clear whether the same would have materially affected the result. So, with the matter, no interim orders called for at this stage.
My
affidavits to be filed by 3 weeks. Yes.
My writ petition become infructuous, my lord.
See, what's the point? Now,
Respondent number 5 may be.
The only thing is that the only question that remains is whether the rejection of this 14 will be correct.
My lord, because my agent was not in there, my lord. I don't know how election was performed, my lord.
Item number 3.
That they don't file affidavit.
Much obliged, Lordship.
By that time, infructuous. Highly obliged, my lord.
Yes.
Please, Lordship. Lordship, this matter may maybe come up at the end of the board, Lordship. The Advocate General is on legs before Supreme Court, Lordship.
We're not giving live coverage of that one.
Lordship, I wish I can give the information.
Yes. So we'll know when he's be available.
Lordship.
4.
Much obliged.
There's one issue though, Milits, even if the matter comes at the end of the board. Now, in the counter that they filed to the miscellaneous case regarding the single tender, Milits, there's one issue which I must point out. They say, Milits, that this decision of whether to proceed with the single tender, it will go before the Board of Governors. Now, that has not been brought to my lords on record before this honorable court. So whether my lords would then want to
submitted, they'll go for Board of Governors. You an affidavit?
Yes, yes, it is on affidavit. They say that within 15 days the Board of Governors has to take a decision on this. Now, that is not before my lords.
See, the thing is that whatever it is, it involves medical supplies. All these PHCs, and also that the matter should not linger or there should not be any hindrance.
Lordship,
tomorrow.
They don't deny the fact, Milits, that there is a single tender. The only thing they say is that it has to go.
Lordship, may I have it in the board, Lordship? The Advocate General will be in better position to clarify this.
But has any decision been taken on the single tender?
Not yet, Milits. That's what the affidavit discloses.
Lordship, but in Lordship, small prayer matter can be taken up. Lordship, the Advocate General will be
already allowed that prayer. There's only that senior counsel said that maybe the matter cannot
affidavit was sworn.
Be conclusively,
This affidavit was filed by them, Milits, on the 16th of July. So they say, Milits, in para 15 that within 15 days, Milits, I can just very quickly read, it is relevant to mention that the final decision in all matters relating to the board governed company is of the board of directors, and the entire issue will be placed before the board of directors within 15 days. Without prejudice to the same, it's so and so. So, Milits, if it has been placed, what is the outcome of that? That would have to be placed before my lords.
Also, you communicate that to the Advocate General.
Lordship.
You can have it then, Milits, after a day or so.
We'll have it because 15 days. Today is the...
Well, it's 15, so it will be 30th.
30 days will be when?
30th, Milits.
15 days, sorry.
30th.
30th, be tomorrow, Lordship.
Let it come up on the 31st, Milits, so at least that 15 days is over also, so we'll know exactly what is the situation.
31st?
Lordship.
Or end of the board?
Lordship, may have it tomorrow or day after tomorrow. Lordship, the Advocate General will be here.
Will be physically here. When he's coming today?
Lordship will be reaching in the evening.
We'll have it on 30th.
31st, Milits.
31st, okay, yeah.
Because that gives them the clear 15 days. So whatever is the position, they can inform the court.
Communicate that.
Lordship.
Accommodation has been sought by Mr. A. Karvanlang on behalf of Advocate General, who is not available presently. Stop. However, Mr. K. Paul, Senior Counsel, has drawn the attention of this court to an averment made in the
para 15 minutes
that the final decision on the single tender will be taken after the Board of Directors, Board of Governors.
Board of Directors
takes a decision. As he submits, as the same been placed before the Board of Governors, the Board of Directors, that the matter can be taken up on 31st.
31st.
Accordingly, next panel lists the matter on 31st, 7/2025 for further orders.
So they can place the instructions as to what is.
He understands.
The only thing is not come in the order, Milits, then we'll be stuck with the situation with.
Lordship.
Item number 4.
Much obliged.
My lord has directed for
yes,
instructions, my lord.
Yes,
everything.
No, my lord, in fact, there are 2 vacancies, my lord, reserved for
People with disabilities.
candidate with benchmark disability. 2 vacancies, my lord. And 3 candidates have applied, including the petitioner, my lord. Now, my lord, 2 form, my lord, reserve category. 1 post is for reserve category, disabled, and 1 for general. Now, my lord, the process is on, my lord. Only thing now remains, my lord, we are making a verification, my lord. That is a mandatory process. With regard to the certificate, the matter is being taken up with the appropriate authority. So, moment it is done, my lord, I can place your lordship the list. It will come. So, this process is not over here, my lord. Lordship can, I don't know, my lord, lordship can.
You mean the writ's premature?
My lord, I will
My lord, writ can't be premature. Why? Because the provisional lease has been already out, and
so
my lord has
this
said,
category is concerned, my lord, we have not yet issued.
Yeah.
and my lord has already seen the provisional this, my lord. And now, my lord, once the
Intellectual, visual, and hearing.
yes, so once the certifying authority, competent authority has certified, my lord, where is the provisions that they have?
Mr.
Yes,
Mr. Sen,
yes,
in the contact details, it is wrongly given here. The Gmail address for Trudy Lingo is given as the 3rd candidate. You can examine. You get it corrected. Or they'll communicate the wrong email address.
No, that we can correct. I understand. I have got
contact details of number 1.
Well, I'll tell them to correct it, lordship. That should have been, my lord, 3rd. For 3rd. That I will correct. No problem. So, my lord, this process is on, my lord. So, for verification, my lord, that university can always, your lordships, because there are.
When can you do it? How fast? Is session starting when?
My lord,
my lord, we are yet to complete the admission, my lord. Admission process just started.
Process is on.
The court thought it was closed.
My lord, no, yesterday 28, my lord. To my understanding, yesterday the 28 was supposed to be the finalization of the lease, my lord, of the students' list, my lord. Yesterday, my lord. Now they have come up with this list, my lord, which we are not aware, and my lord has rightly pointed out. If they have emailed it to somebody, then it has never come to my.
No, we have not emailed anything, my lord.
It's still on our records. Suppose the rejection acceptance, the rejection one will go to the police will be accepted, and
we have not circulated this, my lord. This is from records I am placing before this court.
Yes,
lordship can close this matter, my lord.
Mr. S. Sen, counsel for the Pune University, has submitted that as per you have 3 seats.
Two seats.
2 seats are reserved with persons with disability.
1 for general, my lord, and 1 for reserve category.
1
for general category.
1 unreserved and 1 for
general
reserve category. Stop. It further submits that there are 3 candidates presently who have applied under the PWD category, and the same is under examination. He prays that some time be given to university authorities to finalize the admission process.
After verification only.
Yes, after due verification. Mr. Yubin, on the submissions,
yes.
What do you have to say?
My lord, if that be the case, then I dispose of with a liberty, my lord, to approach us, and when if
yes. On the submission, please that the submits that as on this submission submits that the petition be closed with direction that the verification be done within a.
We have just taken up the verification. Yes. We have taken up the civil hospital report will come. It's up to them.
Enable successful candidates to join in time. Yes, on the submission of the council of the parties and in consideration and noting the fact that the admission process is still on, the incident petition is closed off the direction that the response authorities will conduct a verification process as expeditiously as possible. Yes.
Verification will only lordship, verification of the certificate. With other verification, those things subsequent.
Certificate only.
Certificates.
Verification of certificates as much as possible. With the above noted direction.
Certificate of disability, because those other certificates.
Yes, disability as it is possible. With direction, the matter stands closed.
Item number 5.
Rosie, you filing the report?
My lord, this
Why
matter.
not for hearing today?
My lord, it should be in orders column because,
Should
my
have been
lord,
in the orders, my lord.
there is an order, my lord. It came for reference, my lord, the other day, my lord, for mediation. So we have submitted that the matter cannot go for mediation. My lord, in one of the lordship's orders, my lord, we have some, there is an inquiry report that has to be placed on record, my lord. So I'm praying for time, my lord, a week's time to place that inquiry
report.
So what had happened is after interim orders passed by this court, they had conducted some kind of a spot inquiry that we brought to the notice of this honorable court, my lords, and by order dated
11/7,
11/7, my lords, had directed that the report be placed.
via an affidavit, my lord. So, my lord, I pray for
Yes,
time, my
I
lord.
must first noted this matter has appeared in the hearing list. This matter should appear for orders of, as per order dated 11/6/11/7/2025. Oh no, Thomney. This matter should appear in the order list. Oh, Thomney, no, sorry. Just list the matter in the order column the next date. Stop. Learned GA to produce a copy on affidavit of the inquiry report or any further development in the matter.
My lord.
And also the counter has not been filed, so this matter is.
Yes, my lord. Affidavit in opposition has to be filed. In the meantime, my lord, the issue of inquiry was raised.
Instructions must be filed in the said date, next date. You have whatever you have, because sometimes when instructions we can dispose it up.
My lord.
Well, it's the interim orders may kindly continue.
Interim orders shall continue.
Until further orders, my lords.
Okay, until further orders.
Daily list item number 1.
Yes.
Lordship, your Lordship has heard us to some extent. You have heard us to some extent in the past, and I think the record also has been called.
Arrived because yes, been received.
My only humble submission is that if this case can be sent back to the trial court, let it be tried on merits and decided on merits accordingly, Lordship, because.
But the thing is that how can you allow to go back on merits? That means you allowed your second appeal.
Yes, your Lordship.
Because they've been dismissed on a ground of res judicata, correct?
Yes, your Lordship.
Yes. Yes.
Lordship, but for
Lordship, the only thing is that in the TS 19 of 1982, Lordship, the mother of the petitioner did not take part. The reason being that 10 years period was not yet over, Lordship. As
meaning?
There was meaning of the 10 years period is that, Lordship, on the 5th 12 1987, the mother of the petitioner has given 35,500 to one Lin Sila Jirwa, the relative of the respondent, Lordship, and on the basis of a mortgage of a land, with the understanding that if the money was not paid within a period of 10 years, the land would belong to the mother of the petitioner, Lordship. And that
one thing is a concurrent finding, correct, Mr. Moncla, over two lower courts, correct?
Yes, sir.
Now let's go to the order of the appellate court, because the plane has been we have got the results. We requisite the records of the earlier plane also, correct? That will have. let's see the order and appeal.
Lordship, the order of the trial court is at page 20.
No, the appellate lower court appellate order.
It's at page 78, Your Lordship.
What's the operative part? Well, whether this question has been addressed at all. Why we are looking at this thing, Mr. Moncla, that your contention is that she never took part in the proceedings because at that point of time there was no cause for her to take part. Is that correct?
Correct, Lordship.
Now, where has the lower appellate court dealt with that point? Did you raise it?
Well, Lordship, that has been raised actually, Lordship.
If you raised it or not. If you haven't raised it, you can't raise it now.
I think that point has been raised, Lordship.
It was not. I mean, there was no finding on that point.
No finding on that point because
as we were sitting, this is under 227.
Your Lordship has filed an appeal, Your Lordship.
Oh, the appeal, sorry.
This is second appeal. However, Your Lordship
There
has.
can be substantial question of law. Now, where's the let's see the finding, the approved part.
It's at page 99, Your Lordship.
Yes.
It's at the end of the bottom of the page, paragraph number 8 is.
You kindly read, Mr. Nokla.
Upon proper perusal of the written argument of the learned counsels for both parties, that is page 99, Lordship.
Yes.
And upon proper perusal of the memorandum of appeal and the case records from the learned trial code, it is found that the appellant plaintiff, while filing the title suit number 84 of 2022, has relied upon the documents which were executed in the year 1982. It is also found that the appellant plaintiff at paras 14 and 15 have alleged that the respondent defendant on 14/4/2022 have started claiming ownership of the land and approached the headman informing him that she is the owner of the suit land. On proper evaluation of the above arguments of the appellant plaintiff against the respondent defendant, I am hereby of the opinion that such arguments is very vague and it does not describe a proper action as to how and in what way or circumstances has the respondent defendant has started claiming ownership of the suit land. Most so, the relief spread by the appellant plaintiff refers to the transaction which occurred for the last 30 years. Therefore, in view of the above, I am hereby convinced that the suit does not disclose a proper and substantive cause of action, and the relief spread for by the appellant plaintiff is barred by Limitation Act 1963. Furthermore,
Let's stop there. That means the cause of action arose in 1982, according to your plaint.
According to 82. No, Lordship. According to my plaint, the cause of action arose in 22.
While filing a title suit, has relied upon documents which were executed in the year 1982.
No, Lordship. The document was executed in the year 1987.
Even then, that's nearly 30 years.
30 years.
Yes.
Should I continue? Therefore, in view of the above, I am hereby convinced that suit does not disclose a proper and substantial cause of action, and the relief spread for by the appellant plaintiff is barred by Limitation Act 1963. Furthermore, the appellant plaintiff have duly admitted that her mother was a party in TS suit number 19 of 1982, though the appellant plaintiff has been trying to justify as in the judgment dated 3 November 1992, passed in TS number 19 of 1982, by stating that the learned trial court has referred only in respect of the paddy field of the respondent defendant. However, upon proper perusal of the said judgment, the learned trial court has specifically mentioned in its judgment order, which reads as under the prayer for shop rent payable by the defendant number 4 Prince Siban Khangwir to the plaintiff at the stipulated monthly tenancy amount is hereby however allowed, but only with prospective effects from the date of delivery of this judgment. 12. The defendant 4 in the above judgments refer to the mother of the appellant plaintiff, and the shop refers to the suit land mentioned by the appellant in the present suit. Thus, the claim of the appellant that the present suit land is different from suit land in the previous suit is a claim which cannot be admitted. Therefore, in view of the above findings, I am hereby satisfied that the suit filed by the plaintiff is barred by the principles of res judicata. No court shall try suit or issue in which the matter directly or substantially in issue in a former suit between the same parties or between the same parties whom they or any of their claim litigating under the same title, in a court competent to try such subsequent suit, or the suit is in such issue has been subsequently raised and has been heard and finally decided by such court. In light of the above observation and findings, I am hereby of the opinion that the impinged order dated 6 September 2023 passed in TS 84 of 2022 and Miss Case number 77 of 2022 by the learned trial court does not suffer from any irregularities which requires interference by this court. Therefore, in view of the above, the instant appeal is not merit of the corroboration and the same hereby dismissed. No order as to cause case stands disposed of. This is the impinged order, Lordship.
Yes. Now, see the grounds you stated here at A, at B, C, D, B and C. See, that was never argued before the courts below.
Yes, Your Lordship.
Never argued.
They were raised at first instance before Your Lordship, in the second appeal.
That is what Mr. Nongklau. He never raised this part. That the non-participation of your predecessor in interest was because at that point of time, the agreement dated 5/12/87 was a period of 10 years, and such the deceased mother no appellant need not take part in title suit.
That's my contention, Lordship.
We can't look at that now.
Lordship, admission has been made in paragraph number 5 of the memo of memorandum, which is at page 4, which is the same statement which she has admitted, Your Lordship, that she did not take part because of the reason that the tendency.
No, that's all right. But then why this court was asking the counsel of the appellant to reach, because whether this fact was ever raised before the courts below, that why she's instituting a fresh suit in connection with the same plot of land.
No,
and why? Because she did not take part in the proceedings, whether that was taken into consideration or not.
No, Lordship, we never raised such grounds.
Lordship,
before.
I have stated in my plea that this is a different plan altogether.
No, different lands it's been addressed. That we're not going to interfere in the findings of these concurrent findings with regard to whether it was for the shop and for the paddy field. That's a different part. We're looking at the main part where you see why you did not, take part.
Yeah, the only reason why I did not take part is that the 10 years period was not yet over at that point of time, Lordship. It would have been over in 97, Lordship, and that case was in 82.
Yeah. You lend the money.
Yes, Lordship. My mother lent the money.
The Lordship, in accordance with the agreement, the money is not lended to me. It's lended to one of the co-defendants in the first suit which was instituted in 1982. And the Lordship, non-participation in the entire proceedings before the first suit, it amounts to sleeping over her own right, Your Lordship.
No, that's fine. But then she never agitated that point. That why she not take part in the suit also? Even the plea is not there.
I'm not very sure right now whether I have mentioned that in the plea.
See the plea. See, you come to para 9 of your plea. That's at page 14. There we talk about that money, but you don't say why you're filing the suit. Now, where's the cause of action? You see, cause of action. Where's the part? Where's the paragraph? Arose on. Because we're dealing with a second appeal.
Page 17.
This also will not suffice. You're still in possession of the shop. You're still in possession of the shop.
No, Lordship. The shops have been gutted by fire, Lordship, and the land is being left like that.
Where is this place situated?
That is in
Umsling proper A, Lordship.
And the land is being left like that at present. Neither
Your
of
Lordship,
the
I'm under possession of the entire.
neither of the parties are in possession.
See, Mr. Nonglau, what you're canvassing now is not there in your pleading. In the plain, nor, was it even argued before the two lower courts. How do you propose to seek relief?
Lordship, in this Lordship, can you come to page
and also,
16?
we remember a thing that the appeal will be only on substantial questions of law also. Where has the lower appellate court or local erred in law? To such an extent that the second appeal will be examined. It's a very short compass second appeal. Now you're asking facts. It may be a mixture of law and fact also sometimes, but in this case, it's purely factual, which you're saying, and the argument that you're forwarding that doesn't find place in the findings that it was 10 years, so I don't take part in the suit. So I'm filing a fresh suit. That also will not hold.
Lordship, in fact, during those days, the shops were in the
during those days is fine, but then in the pleadings should have come that the specific pleadings that why your suit won't be barred by the litigator, because this suit was filed earlier on, decreed. You were a defendant, correct?
Yes, Lordship.
Were you plaintiff or defendant? The first suit.
I was a defendant.
Defendant. You were made defendant. You present interest.
Lordship.
You did not participate in the suit. The suit was decreed against you. The decree also mentions the paddy field and the entire suit land. Now, after how many years, suit was decreed in 1990?
92.
92. Suit was decreed in 92.
Yes, Lord.
Instituted in 1982.
92.
Then 92, 10 years, 92 till 2022. Then you say your case is that suddenly someone's come to interfere with my possession, and there was some loan that someone had taken and which has been repaid by you.
Not repaired, Lordship.
Or just whatever, yes. Or that not repaid.
Not repaired for the reason.
And so you.
Had it been repaired, I would have.
That has not come anywhere. So you take a call. Otherwise, even there's no substantial question of law to be decided. Also, it's only facts. And even on facts also, even if the court extends its inquiry to look at the fact also, then as per the pleadings, that's not there. So your second appeal won't survive. I understand that there must be a genuine grievance, but it's been too long. So what will we do? Dismiss it at admission hearing stage only.
Should we read it continue first?
Look, you try to, but then.
Lordship, humble submission, Lordship, the judgment, an order dated 3rd November 1992. Since passing of the judgment and decree, Lordship, they have not preferred any appeal.
That is there. Now,
that is
there also.
Yes, Lord.
That's why it's part of the litigator.
Yes, Your Lordship. And clear statement has been made in the judgment, Your Lordship, that even despite two notice has been served to the defendant.
So that is what Mr. Nonglau is saying. I didn't take part because I thought that 10 years.
That's been admission, Lordship.
But that won't be good because yes. To disposal of Mr. Nonglau. Then extinguish your rights forever.
It's up to your Lordship.
So kindly dispose of this taking.
In fact, here, Lordship, in page 16, para 16, here should I read? It is also admitted the fact that the defendant is the owner of the party field, as mentioned in the judgment. In the judgment order dated 3rd November 1992, in TS 19 of 1982, but she is not the owner of the suit land, which has been mortgaged to Linsila Jerwa, to the mother of the plaintiff, Liet Kafrens Sibon Kawir, during their lifetime. This actually, this suit of TS 19 of 1982 was with regard to the paddy field and other land, but not this. Not this particular.
Then you should have filed appeal at that point of time against the decree that the You know, why was...
But then, Lordship, again I was not taking part, so how could I?
Yes, that is what happens, you know. This is 22. Earlier, you played. Even a deed of mortgage exhibited in the earlier suit.
Yes,
Your Lordship must be.
Yes.
Yes.
Your Lordship, in
One
the...
second. Yes. See, you see it is not there, the first plane. You look at this page, this is the records. That's why you requestion the records. You kindly see, Mr. Nongkla.
Okay.
This is the plane at page 136 of the records. You just have a look, yes. This, the declarations for what? Declaration, the original plane, that's the title to 1992. You have a look also, Mr. See the prayer. Decree is.
To give a degree for declaration and confirmation of right title of the plaintiff about the paddy field and shop houses and the defendant number 1, 2, and 3. And defendant number 1 to have no right or title about the same.
So, there your case is over.
Yes.
Well, Your Lordship, we didn't take part, no doubt, we didn't take part at that.
I dictate. I heard Mr. H. Nongkla, Learned Counsel for the appellant, Mr. S. Arlindo, Learned Counsel for the respondent stuff. This Mrs. Miscellaneous second appeal, Mrs. Appeal bracket second, has been preferred against judgment and order dated 29/1/2025, passed by the Judge District Council Court in Business Civil Appeal number 10 of 2023, arising from where's the trial court judgment?
It's at page 80, Your Lordship.
80?
80, yes.
Trial court?
Sorry.
Not appellate court.
Trial court is at page 20, Your Lordship.
Come now. From Miss Case number 77 of 2022 in TS number 84 of 2022. 22. Stop. It is noted at the outset that the instant Mrs. Appeal second bracket second has been preferred against concurrent findings of the two subordinate courts, whereby the suit filed by the appellant has been dismissed on the grounds of res judicata. So, next paragraph, Mr. H. Namkhala, learned counsel for the appellant, has submitted that though it is a fact that the predecessor interest of the appellant was arrayed as defendant number in the earlier suit.
Not three. Defendant number 4.
Defendant number 4
the earlier suit.
In the earlier suit, and the said suit.
Lordship, but in that order which I have just read, Your Lordship asked me to read, I think it's, I guess, defendant number 1, 2, and 3. No respondent number 4 is mentioned there.
That we cannot go into that now, because the whole decree is for the whole party field and shop lands and shop houses, and also that we'll not go into that anymore. No,
so whatever Your Lordship deemed.
She did not contest the same, and the same has proceeded ex parte against the said defendant. That's late Principal Kongwin.
Lordship, yes.
Yes, late Principal Kongwin. It's also fairly submitted by the learned counsel appellant that against the judgment decree that was passed in the TS number 19 of 1982, no appeal or revision was ever preferred. Stop. The limited ground of appeal which has been canvassed by the counsel for the appellant is that the reason for the non-participation of the predecessor interest of the appellant was that there existed a mortgage,
Lordship, yes,
mortgage deed which had been executed on 5/12/87 in favor of the earlier respondent, defendant number 4, late Principal Kongwin, which allowed 10 years for the said loan amount to be liquidated, and as such, at that point of time, he submits the 10 years period having not elapsed, the predecessor interest chose not to participate in the proceedings. The cause of action, according to the appellant, thus arose only in 2022, when the respondents dispossessed.
Encroach.
Not encroach shop. How would encroach to a shop?
No shops are there.
Yes. When they questioned her title. Stop. He submits that both the locals below, having not appreciated this fact, have thus committed error in law and fact in dismissing the title suit on a ground res judicata. Mr. S.R. Lingdo, learned counsel respondent, in reply has submitted that the appeal is unsustainable inasmuch as, firstly, as admitted, no appeal or revision was preferred against the decree passed in 1992 with regard to the same suit property, and further, the appellant, having chosen not to participate in the earlier proceedings, has waived any further rights to agitate for the same. Stop. It further submitted that even the ground made as ground advance in the appeal was never raised in the plaint or in the memo of appeal before the lower courts. So he closes submissions by he closes arguments by submitting that no case made out, nor is there any question of law involved for admitting the instant appeal. Stop. This could heard the counsels for the parties and also examine the records that have since been requisitioned. Stop. A perusal of the memo of appeal reflects that the where's the memo of appeal? Page yes, reflects that. Abyss page 49.
Yes, Nashim.
Reflects that the ground is as the approved memo appeal reflects that the grounds stated therein is twofold. Firstly, that this Linsila was a plaintiff at that point of time.
No, Your Lordship. She's the defendant number one.
On the ground that one late Linsila Jarwa, who was arraigned defendant number one in TS number 19 of 1982, could not repay the loan amount to the mother of the appellant, late Principal Kongwir, within a period of 10 years, with effect from 5/12/1987, and as such, the suit land or shop would be owned and possessed by the mother of the appellant. The other ground taken is that in the earlier title suit number 19/1982, which was decreed on 3/11/1992, was before the expiry of the said 10 years, and that the same related only to the paddy field but not to the shop houses which form part of the suit land. On these two grounds, it appears the suit had been instituted. Subsequently, by miscase of the trial court. Subsequently, there was a page for 20.
Yes, Your Lordship, 20.
Yes, subsequently, on an application filed by the respondent under Order 7 Rule 11 of the CPC, the trial court, by order 6 September 2023, on a minute perusal of the entire facts and circumstances of the case, had come to a finding that the plaintiff, that is late Principal Kongwir, had not contested the suit, that the suit was barred by limitation, and that the suit and the subject matter and controversy was the same as the former suit, which has since been decreed. Stop. The fact that no appeal or revision had been preferred was also noted by the trial court, while allowing the application under Order 7 to 11. Stop. On an appeal thereafter, on an appeal from the said order thereof, the Court of the Judges Council Court, by order dated 29/1/2025, past missile appeal, has upheld the findings of the learned trial court and had also observed that the contention of the appellant that the suit dance was different was incorrect, inasmuch as in the order of the learned trial court in the TS number 1982, mention was specifically made with regard to the paddy field and also the shops in question. As such, on the ground res judicata, the said appeal was dismissed. So, next paragraph, as noted earlier, this appeal has been preferred against concurrent findings rendered by the two lower courts. Stop. This court has given, though this court has given due consideration to the entire facts and circumstances, but however notes that the main submission that has been forwarded advanced before this court, that the ground for non-participation of the predecessor interests of the appellant on account of the mortgage deed whose term was subsisting does not find place either in the plaint nor in the pleadings, nor was the point that was ever addressed before the two lower courts. Stop. So, however, in looking into the records and also on the other facts, attendant facts, it was noted that the fresh suit instituted by the appellant only in 2022 relates to the same subject matter dispute which was subject matter in TS number 19/982. Further, the contention that the earlier suit only referred to only to paddy field also is incorrect, as a perusal of the plaint clearly shows that decree was sought for paddy field and shop houses. And that's why, there being no error in the findings of both the subordinate courts, nothing survives the appeal, therefore also being incompetent for not raising the grounds which are sought to be raised before this court. The same being devoid of merits is dismissed. Request to be returned. Yes. Sorry, Ms. Nonkla, you tried your best, but
I'll be obliged.
Item number 2.
Two and three, my lord. I'm praying for 2 weeks' time, my lord.
Who's the petitioner?
Mr. P.K. I've been absent for last 2-3 days, my lord.
Is he all right? Have you?
He's all right. I see him around.
Now is a month also, so he'll be busy.
I'm praying for 3 weeks' time, my lord.
Yeah, 3 weeks time is prayed alone.
3.
Deputy. Shema.
Yes.
4.
Yes.
My lord, for respondent number 7, in this case, for respondent number 7, we have already filed our wakalat number, my lord. So I'm seeking some time for filing the affidavit.
What?
For respondent number 7. For respondent number 1 and 6, we have already filed. For respondent number 7,
Lordship, I seek some more time to file rejoinder to the affidavit.
1 to 6.
1 to 6, Lordship.
Yes. Counsel for the petitioner, please for around for a 2 weeks time. To file rejoinder to the affidavit file with 1 to 6. And counsel petitioners also around similar time to file affidavit house number 7. Just after 2 weeks.
5.
May please Lordship, as per the last order, we have taken a press step to issue the notice to the private respondent, your Lordship. Now still the service is still awaiting.
Yes. You file an affidavit.
Yeah, fine, Your Lordship.
You filed it. Very good. Yes. Officer indicates that notice is not complete on the respondents 5, 6, 8, and 9. It's after 2 weeks to await service report.
Much less, Lordship.
Stop the petition of liberty to obtain status of service.
Lordship.
Item number 6.
Yes.
My lord, we have received the notice and I am appearing on behalf of the respondents here, my lord. My lord, this petition, my lord, calls for dismissal with an exemplary cost, my lord. Here, kindly look, I can be held liable for contempt either of a civil or of a criminal. Civil for disobedience of the court or criminal for scandalizing the honorable court, my lord. Which order did I disobey? Which order did I, by what way did I scandalize the honorable court, my lord? Here, now this petition is actually, my lord, is a abuse of the process of law, my lord, and misuse, my lord, of law. My lord has disposed of my writ petition, saying that the matter was referred to the authority, and when an authority will issue a notice, I will appear. That is what my lord has said. Now, authority has not issued a notice. I have inquired 2-3 times also, my lord. They are yet to issue a notice, my lord. So now I don't understand, my lord. What is this?
What contempt filing?
Lordship, by virtue of your lordship's order, they are approaching the police authority. Lordship, and they are misinterpreting the entire judgment of your lordship.
Why are you police authority for what?
My lord,
Lordship, I'm utilizing my own land.
No.
So they are using police authority to stop me from entering into my own land.
No, that is
now, your lordship, the entire dispute
this comes from where? This dispute arisen from what?
Your lordship, at first instance, I'm the owner of the land. Then there's Western Bypass acquired the land. So not to the extent they claim ownership over my landed property. So the alignment of the land, your lordship, where it's supposed to be required for the Western Bypass has already been acquired by the authorities. So your lordship, the entire matter and controversy in the writ proceeding, your lordship, it's with respect to compensation, and there's no other dispute with respect to the matter of the land which is adjacent to the Western Bypass. So I'm utilizing my vacant portion of the land, your lordship, and they're using police force to stop ensuring this order of your lordship that there's a case pending and I should not enter into the land, and the police authority believing
if it's outside the acquired property.
Yes, Lord. And they're using and stopping me.
Acquired is still you're cultivating.
I'm cultivating now. We are poor, Lord.
And the land has been acquired.
No, Lordship, but in a separate.
How do we look at a contempt matter?
There's no contempt at all.
So they're using the police force, Lordship, to interfere in my possession.
Proceedings, you know.
Yes.
You know very well.
Your Lordship, clear direction is given that it's for the writ petitioner upon receipt of notice to appear. But they keep on saying that there's a land dispute pending and there's a suit pending before any other court by virtue of presenting this, Your Lordship's order before the police authority.
Absolutely wrong.
Are you using for police authority?
No, I'll tell you,
They
my
have
lord.
even
what
seized portion of some.
allow me to inform the court, my lord. My lord, pending notice by the authority, my lord, pending authority, they have encroached into their subject matter, my lord. Now, in order to take evidence, my lord, I went and took photograph of their activities, my lord, so that as well as to collect the proof, my lord. Now, what did they do?
Proof regarding what? Regarding the acquired portion of land is yours.
My lord, the entire stretch is mine, and I was saying, yes,
we cannot adjudicate this matter here.
Exactly, we cannot do, my lord.
So don't there should not be any activities that will give rise to further confusion. If the matter has gone on section 64, right?
Yes,
it's gone to the special judicial officer.
Yes.
Now the only question is, if you claim, both of you have got a claim, counterclaim, right?
Yes,
to a certain piece of land,
correct,
which has been acquired for the purpose of the road. Now that dispute will go for the special judge. He'll see
exactly, my lord,
it belongs to whom.
Yes.
Then compensation is already there, be paid to rightful person.
Correct, my lord.
Now in the intervening period, now that is a totally different cause of action. Then
different cause of action.
They are abusing your lordship.
Cause of contempt, my lord. Yes, my lord.
Because of contempt, but you can take recourse other remedy.
Yes, my lord.
Yes, your lordship.
There are other proceedings in the criminal procedure also, where such
lordship,
matters.
I've been called to the police station.
That is a non-FIR case. They should have drawn up other proceedings.
Yes. So, but there's no such other cases as such.
Then you file an application. Yes, the contempt application, it appears has not made out. Has not. Contempt application filed by the contempt filed petitioner does not make out any case of violation of any orders of this court or any conduct that would call for institutional contempt proceedings, or only matters closed and disposed of.
Your pleasure.
7.
But here, as far as the state respondents are concerned, my lord, the
already filed.
No, my lord.
Very good.
Affidavit. No, my lord. Affidavit is prepared and sent, my lord. It is coming from Tura, my lord.
Who is the person responsible?
SP Tura. So I'll pray for at least 2 weeks.
Why is not filing affidavit?
My lord, it's already prepared.
How many times did you have taken time?
My lord, on the last occasion, only recently I've sent it to him, my lord.
1 week's time.
1 week.
Your Lordship,
11/7.
respondent number 5 I've already filed, my Lordship.
Very good. And you are respondent number?
4, Your Lordship, I'll be filing, Your Lordship.
Course of the day. Mr. Q praise for the allowed 1 week for a time to file affidavit behalf of number 3. MSBB PASA submits that on behalf of number 4, the affidavit will filed in the course of the day. Draft number 5 is already on board as per submission of MSA Harmandai. It is after 1 week.
Item number 8.
May it please, Lordship. Lordship, in this matter, Lordship, we couldn't file the affidavit yesterday because, Lordship, there was some technical error and registry had raised some objection. We'll file it in the course of the day, Lordship, today.
Lordship, in this case, I am appearing on behalf of the respondent 1. So, Lordship, just we've gone through this paragraph and we find that here, executive administrative control of this DFS is there in respect of the claim. So, Lordship, in the DPT, they are issuing the memorandum, this correct. But here in this case, Lordship, DFS, this Department of Financial Service will be there.
One thing, Mr. Debnath, are you filing affidavit or not?
Lordship,
I do not know, or court does not know what's inside the instructions.
So Your Lordship, here, just my...
You won't file affidavit?
I will be filing the affidavit.
Then?
Your Lordship, this here, main party will be here, in respect of the bank.
Will be here means where?
In this petition, they are not make the party, Your Lordship.
Who's the main party then?
Here will be DFS, Department of Financial Service.
But we are not aware. Yes, Mr.
Lordship, all the
if I may bring to your Lordship's attention, as per the last order, was expected for the affidavits to be filed, to be brought on record, your Lordship.
Regarding State Bank?
Yes, Lordship.
Reservations?
Implementation of the reservation,
Lordship, these matters, all the bank matters are dealing by the Department of the financial
That we don't know. That's for Petitioner to find out. Yes, Mr. Pandey.
Lordship, I'll file it in the course of the day, Lordship.
Mr. Pandey on behalf of number 3. What about 2?
State is not filing a lawsuit.
Submits that after the final course of the day. Mr. R. Debnath, CGC, behalf of number 1, submits that perhaps the relevant party has not been added as respondent, which is the director of.
This is the administrative control of the DFS, Department of Financial
Services. Yes. Stop. But you file affidavit on behalf. You won't file affidavit.
So, Your Lordship, if I file this Department of Personal DPOT, then there will be another confusion.
Your Lordship, all the notifications has been issued by the respondent number 1, Your Lordship. The office memorandums as well.
However, director of the Department of Financial Services. Stop. The same is counted to by Mr. Lafonguya, who submits that all the impugn notifications and letters have been issued by the DOPT by the respondent number.
Respondent number 1, Your Lordship.
Stop. Accordingly, Mr. They have not granted 2 weeks for the time to file affidavit. Yes. File whatever affidavit you file.
9.
Most of them.
Please. Yes.
This is also resignation of a doctor from Assam Rifles. He is a radiologist, my lord, and he also wants to resign. So I've received preliminary instructions, my lord.
You're serving as what?
He's a radiologist. He's a doctor.
Radiologist. They allow him to resign?
No, my lord. We are saying that against the requirement of 3, we only have 2 at this moment, my lord.
Where are you serving right now?
Right now in Dimapur, Chandrasekhar, Sukhoi. I'll file affidavit, my lord.
Yes, so Dr. M. Muzika submit instructions that the respondents are unwilling to grant NOC to the request.
Oh, he wants to go on voluntary retirement.
Yeah, to the request for voluntary retirement.
Yes.
Stop. He please not to file an affidavit. Yes. Well, this how much time?
6 days.
Yes, 3 days after 3 weeks for affidavit.
Highly.
Hearing, item 13.
Lord, this matter, my lord, pertains to export of boulder stone to Bangladesh, my lord. This subject matter is international trade. Lord,
what is your grievance?
My lord, my grievance is, if my lord will see, Annexure 1 series, these are the import-export code belonging to the petitioners, my lord. And page number 22 onwards, my lord, these are various difficulties that has been faced by the petitioners while exporting the boulder stone to Bangladesh. I'll just read out, my lord, this letter dated 11th August 2022, so that we can at least come to know what are the problems that has been faced by the petitioners, my lord. If my lord will see, letter dated 11th August 2022 at page number 22, the serial number 1 of the letter, it says some of the irregularities and mismanagement are mentioned below. Number 1, non-entry of vehicle at allotted parking according to your order number so and so, dated so and so, point number 7, that all the boulder trucks replying to Bangladesh should enter into parking and exit from parking on first come first served basis. But even till now, some of the trucks are not entering the allotted parking and plying blindly.
What do you mean plying blindly?
Well, they have been allowed to go without entering the...
So you mean to say that there's a parking area, all trucks exporting boulders enter that?
Yes, my lord, this is actually...
Compulsorily,
my lord, these are private parking. Private parking, but authorities has made it compulsory for people to enter into that private parking, and they are collecting 600-700
per truck. So my lord may kindly imagine the amount of collection, 200-300 trucks a day, which enters into that private parking, and where this money goes, God knows.
No, we don't know.
Yes.
Now the thing is that, but what do you see the other truck? So are you for that it should go to parking, or that you can be allowed to go freely?
I am totally against all this, my lord. But what has happened, even though the authorities has made it compulsory, but some of the trucks, it was plied without entering into the parking. That is what which has been pointed out in this letter. And the second, my lord, the point which has been raised, illegal issuing of parking COVID slip. The parking owner till now issues parking COVID slip to REMEIA even if they do not enter the allotted parking, and issuing of parking COVID slip is not as per first come first serve basis, preference given to REMEIA by the parking owner. Now here, my lord, RMEIA, this is one of the association that is respondent number 7 in this petition, my lord.
Who's for you?
Yes. Now the authorities
engaging all this illegal work.
No, authorities, my lord. No. Yeah, I will show, my lord, how they have been engaged in all these illegal activities, my lord. Now authorities, my lord, they have allowed the respondent number 7 to regulate, to have control over all these international export, and they are the one.
Which point is this?
These are, my lord, Tamabil.
What point?
Tamabil, my lord, this Dauki Tamabil, my lord, that is the route, my lord. Now here.
And this is parking where?
This is parking in that area only, my lord. The
where?
Place is not mentioned here.
Then how can you not mention the place?
No, this is the letter, my lord, which has been, because this.
Where's the letter? 21/7/2022. You annexed it here.
My lord, these are all illegal activities, my lord. I will come to all these issues, my lord. Let my learned
let's
friend.
See letter 22. I don't want to hear that you did not annex it.
Of course, my lord, this is not here.
Then,
my lord, that this is one of the aspects. But
your main grievance was founded on the letter according to your order number so and so. Where's order? Have you impugned it,
my lord?
You should impugn this first.
This is not only one of the grievance, my lord. I will come to all other aspects. The main grievance are, my lord.
First. The first you draw attention to the court, you read this first. Now where's the order from where this illegality has emanated?
My lord, I can bring that letter. I can bring it by affidavit, my lord. Now, my lord, may kindly hear.
This your petition, you file afresh if you want. You have the same situation.
My lord, may kindly give me 5-10 minutes, my lord. I can place my case.
5-10 minutes?
Yes. Now, my lord, may kindly see what are the problems that has been faced by the people, my lord. Now, in my subsequent letters at page number 24, my lord. Page number 24. The second paragraph I will read, my lord.
You are meaning exporter and minor society control everything, according to you.
Yes.
They're like mafia.
Right.
Okay.
And my lord, may kindly see page number 24. Paragraph 2, I will just read out, my lord. The parking owner did not obey your order regarding the discontinuity of.
See, where first on 22? What's the 22?
Page number 24. Page number 24, my lord.
Yes, Mr. Shulai.
Now, entire
is
subject
going on now or stop?
Still going on, my lord.
I think it is stop, your lordship. Because there
is still going on, my lord. And my only one contention is, my lord.
I think there is
the regulation of international trade, my lord. This is covered under entry 41 of the union list. Now here, the state is not competent even to regulate. Now,
regulation of export trades at the export point.
Yes.
To land border, land border customs station or customs point. Not a question of where's happening the hills.
No, no, my
parking in entry, exit. The order, annex the order by which you've been compelled to park.
My lord, the order which I have challenged here, my lord, by which they have regulated, my lord, will come to page number 36.
So far, the state is concerned, lordship, we are just regulating
page number 36.
Traffic movement, your lordship.
Page number 36, my lord. Page number 36. It says in partial modification to the order number so and so regarding regulation of the international border trade details at so and so of the said order may be corrected thus. A daily limit of 475 vehicles are to exit their respective quarries as per limit shown as under. And my lord, how many vehicles will be going to the will cross the border, my lord? That is also been regulated by the state. Whereas the law is already in place. The foreign trade.
This is not regulation of foreign trade. This is regulation just that the roads will not get damaged.
Now here, my lord, the entire how many trucks will go, what is the procedure they will follow, that has been regulated by the state, my lord. That is where the grievance is, my lord. The foreign trade development and
forest department party. No.
They are not party, my lord, here in this
Then
case.
who's in charge of minor minerals? They mean party. No. Where extraction is just boulders come to minerals.
I am only aggrieved by the part of the action, my lord, of the state.
My lord. You know, when annex the requisite documents, you expect this court to have a roving inquiry.
My lord, my only grievance is, my lord, the action taken by the authorities, my lord, here.
See, you might feel very aggrieved with certain people. You're operating your trucks. You feel you've been given, you know, unjust kind of a deal, where only some trucks, some associations are allowed to ply.
That is where my grievance is.
You're made to stand on the roadside, not allowed to ply your trucks or border.
Right.
That to be addressed by district administration. Not
yes, if our grievance is addressed, my lord, we have no other issue, my lord. Let it be.
File additional affidavit allow you. Bring on other record 22 order.
My lord, I will bring it up. My lord. If the grievances are addressed, my lord, I have no other issue.
You have been made the correct.
Yes.
Lordship, what the state has done here, your lordship, is just because there is a trial. Lordship is aware that Peninsula Dowkey Road, your lordship, is very congested, your lordship. We have done that to regulate the free movement of vehicles, your lordship.
But it should be fair, my lord. How can a private association has been allotted with all the task of regulating, whereas we have been deprived? That is the only thing, my lord.
Provide the materials.
Right.
In the course of hearing, Mr. Please email out to file additional affidavit, bring on record additional materials which are relevant in the matter.
Lordship, instead of filing that,
you withdraw.
Let the petitioner withdraw. I'm filing a fresh, lordship.
Not necessary, my lord, will pursue with this case, my lord. I'll bring it on record. I'll bring it on record, my lord. This has been
next
15.
Before you come to court, you have to strategize and plan. That is a basic duty of a lawyer. Yes.
15.
Yes, Mr. Datta.
Lordship, the case is all about this regularization of the laborers with temporary status in accordance with the scheme of the Government of India, which is called the Casual Laborers Grant of Temporary Status and Regularization of Laborers. So, we have been granted temporary status, Your Lordship, as per the scheme. So, under the same scheme, our services should be regularized.
Let's see where's the scheme. You have an exit here. What does the scheme say?
The scheme says after 3 years.
This is the
after the grant of temporary status. After 3 years.
Where is this page 34?
Lordship, I am going to find it.
You're working in Nehu?
Nehu.
You're covered by the scheme?
Yes, we are covered by the scheme. The Nehu has adopted this scheme. The scheme is at page 28, Your Lordship. This scheme shall be called Casual Laborers Grant of Temporary Status and Regularization Scheme of the Government of India 1993. And the scheme will come into force with effect from 1/9/1983, 1st September 1993, Your Lordship. So we got this temporary status.
Yes. Yes.
Yes, Lordship. After temporary status was granted, we filed representations for regularization of our service. But our representations were not disposed of. So we filed a writ being number 103, WPC number 103 of 2023 for regularization of service under the scheme of the Government of India, called Casual Laborers Grant of Temporary Status and Regularization of Service. After that, the court passed an order, Your Lordship, passed an order dated 3/5/2023, page 21, Your Lordship. Page 21.
Yes.
The operative part is, that is para 6. In view of the matter, the writ petition is closed, and at this stage, by directing the university respondent number 3 and 4 to dispose of the representation within a period of 4 months from the date of copy of this order is presented before them. So after that, we receive a letter from the respondent university dated 12/9/2023, Your Lordship, at page number 24-25. 24.
So, what happened now?
So this letter is being challenged here.
Why?
So, Your Lordship, this is not in accordance with the scheme.
Okay.
This is not in accordance with the scheme. And please see para 7 of my petition, Your Lordship.
That means the Nehru to decide, not the ministry.
Yes. That even if it is assumed that the case pertaining to so and so referred to respondent number 3, as is apparent that aforementioned case of regularization of service of the petitioner has been shelved and pushed into cold storage, leaving no scope for the petitioner to raise the issue with respondent university. I'll read the letter so it will be clear.
Read letter. I've seen letter just now.
Yes.
They've sent to ministry. Now, what does the scheme say? How do you say that their action in referring it to the ministry is not as per the scheme?
That is not, that is redundant, not required, Your Lordship. It is an autonomous.
Where is that in the scheme? Where at the level?
No, it is not there in the scheme.
Then, Mr. Sen,
it is not there in the scheme.
Position?
No, my lord, position, my lord, we have granted them the temporary status, my lord.
After 3 years, they'll be, now they are being paid according to Group D post.
No.
But then, even because temporary and casual is different in central government.
Yes. No, my lord, what happened?
Because if it is casual, that means it's casual. Temporary means he's given some allowances. He's treated as Group D. Correct?
Yes.
And then after a few years, then
2 years.
they are entitled to regularization.
After 3 years, they are entitled for regularization against the vacant Group D.
Of course.
Now, what the problem happened here? Following the 6th CPC, my lord, Group D post has been abolished. There is no more Group D post. Now, where we can accommodate, my lord? Because post, we do not have the right to create any post. So these are created by the UGC. And this fact has been placed before the UGC.
Where is the affidavit? UGC is all abolished, the post.
Group D post has been abolished, do not exist.
Yes,
Lordship,
Dr. P. Agarwal.
Lordship, not abolished. Please see their affidavit. Your Lordship.
You should have made a submission in the beginning of the hearing instead of making it now. You supply a copy of the affidavit.
Lordship, please see.
We can't continue, Mr. If this is UGC abolish the Group D post, we can't continue, Mr. Datta.
No, it is not abolished. See their affidavit, Lordship. I'll read it. It is not abolished.
Yes.
I'll read para 8, page 4.
Yes.
Sir, the respondent university does not have any mala fide interest whatsoever to interpret the recommendation of 6-pay commission report with regard to Group D employees. It is factually established that with the implementation of the 6-pay commission, the elsewhere Group D posts have been redesignated, not abolished, Your Lordship.
Okay.
It is in their affidavit. Redesignated as Group C with common designation as multitasking staff.
So the scale will be different.
Scale will be different, Your Lordship. After revision, it will be different.
Anyway, Mr. S.N. M.S. Dr. P. Agarwal, counsel for UGC, respondent number?
Respondent number.
Respondent number what?
Respondent number.
Number?
Number 3.
2 or 3?
3. University Grant Commission. 2. 3, Your Lordship.
Respondent number 3.
3.
Submits that a copy of the affidavit filed by the respondent university has not been served upon stop. According to this matter, after 2 weeks of further hearing, copies you first kind of supply copies
Even
supplied.
Even the read petition, my learned friend, is all the annexes are not there.
Well, if you supply copy to UGC also.
File there.
17.
Obligement.
Obliged.
We can't overlook any objection, Mr. Sen.
No, sir.
Yes.
This is that case whereby my representation has been disposed of, Lordship, without any reason of finding, so to say.
You got any authorities?
Lordship, I've got some authorities. Lordship, before I place the authorities, I'll place some notifications, Lordship, so far as ACR is concerned, Lordship.
If I remember correctly, your claims only that they can only re-examine only for those years for which he has not communicated to you, correct?
Lordship, only for
But then, according to them, that to consider for promotion, they have to look at the other years also, right from 2006, 2007, your entire track record.
That
is your submission, correct? Or you don't know what submission he made?
Yes, Lordship.
You remember what submission he made?
Because your Lordship's order
No,
is
I don't
clear.
think he made submission, it's just finding of the court.
Your Lordship's direction is clear on that aspect. So far as my representation is concerned, the relevant parameters for promotion should be considered. That relevant.
What are parameters of promotion?
That means the relevant 5 years.
Only?
The only relevant 5 years, Lordship. Lordship, can you come again to your
Have you upgraded
No,
have you upgraded the grades?
The adverse? No, Lordship. They have not. They have not upgraded my ACR. Now, what happened, Your Lordship? Before even the preceding year also, Your Lordship, I was graded 7 points, Your Lordship.
Yes.
Even in the preceding year, Your Lordship. So now in the next year, Your Lordship, they have graded me 5. So now there was and the same officer, Your Lordship, the same IO and the same reviewing officer were the same person at that relevant point of time, Lordship. In 1 year they've graded me 7 and the other year they've graded me 5. And there's no warning letter, no communication. No,
we are beyond that. The thing is that what are parameters of promotion? Whether the authorities are confined to only examine those years for which the remarks have not been communicated, or whether they can go beyond that.
No, just so far as your Lordship is only for the relevant 5
Show
years.
that authority.
Lordship, before the authorities, I'll come to these notifications, Lordship.
No, I just want to clear up the air first. Show the authority regarding parameters of promotion.
Lordship, there's one judgment which is new. 2022 SCC Online SC 1291.
What does it say? For purpose of considered promotion?
Lordship.
In the context of ECR?
In the context of ECR, and representation has been rejected, and so to say, Lordship.
Where is that?
Lordship, 11 paragraph would be page 19, paragraph 19, Lordship. Am I allowed to read, Lordship?
Yes.
In the present case, the learned tribunal as well as the High Court have directed the department to review the case of the respondent by ignoring the below benchmark of good in the year 2007-2008 mainly on the following grounds. One, that in the earlier years, the very reporting officer reviewing of authority awarded very good for the years 2005, 2006 and 2006, 2007, and the very reporting officer reviewing authority has given below benchmark good for the year 2007, 2008, and therefore the same is arbitrary and there is no basis to award the below benchmark good. 2. That before the below benchmark ACR good for the year 2007-2008, no opportunity was given to the respondent officer to improve himself and no deficiency was pointed out. And 3. That no opportunity was given to the respondent officer to make representation against the proposed below benchmark ACR of the year 2007-2008. While giving the opposite findings that while arriving at the opposite final conclusion, the tribunal as well as the High Court have heavily relied upon the decisions of this court in the case of Sukhdev, Devdutt, Abhijit Ghosh, Dastar and Sukhdev Singh. However, in considering the above said decision, it emerges that in the opposite cases, the adverse ACR either were not communicated at all and or on facts found to be inconsistent and suffering from lack of bona fides. Para 21 Lordship. In the instant case, the respondent was graded as very good in the ACR for the years 2005, 2006, 2006 and 7. However, in the year 2007-8, he was graded only good despite the fact that for all the 3 years, the reporting and reviewing officer was same. Lordship, Para 23.
What is the conclusion?
The conclusion is that, Lordship, since the adverse ACR of 2007-2008 was not communicated to him, and even the preceding, in this case, even in the preceding years also, he was graded very good. But the fact that they were the relevant year of 2007, 2008, that was not communicated to him, Lordship. And second ground is that the same IO and the same RO, Lordship.
That was he upgraded?
He was upgraded, Lordship. The finding is at page Para 30, Lordship. Para 30. This is the final observation of the court, Lordship. Therefore, in view of the above and in facts or circumstances of the case and considering the fact that though the respondent was graded as very good in the ACR for the year 2005-6 and 2006-7 and was graded only good in the ACR for the year 2007-8 by the very same reporting and reviewing officer despite the fact that... No, Lordship, Lordship, kindly... There's another direction. However, no valid reasons are given for rejecting the representation. We are of the opinion that in view of the opposite circumstances, the learned tribunal and High Court have not committed an error in directing the department to call for review meeting of the screening committee to reassess the suitability of the respondent for the purpose of grant of so-and-so, and while doing so to exclude the ACR for the year 2007-2008, Lordship. So direction was given, Lordship, to the department to conduct a review DPCA, Lordship, by ignoring the adverse ACR.
Of which was not report.
16-17, Lordship.
Your 16-17.
And in 15...
So seeking the same prayer that exclude the 16-17.
To exclude the adverse, Lordship. That is my prayer at this stage, Lordship. And the ACR itself is invalid, Lordship, because the SRO has endorsed the ACR after 2 years, Lordship. That is beyond the prescribed limit for any for completing the ACR itself, Lordship. So my humble submission is that, Lordship, this matter may be sent back to the respondents, Lordship, and to take up to pass a reasoned order, Lordship, by ignoring the adverse ACR, Lordship. Now, Lordship, can you come to my petition?
What other authority you have?
Lordship, so far as the other authorities are concerned, Lordship,
parameters of promotion. I mean, the last when this matter was heard, it stopped
quite
there.
some time, Lordship.
Quite some time
Lordship,
it stopped there.
Lordship, can you have 1997 4 SEC?
Yes.
Volume 7.
1990.
1997, Lordship. 1997 4 SEC, page 7. Now, this judgment pertains to the object of writing ACR, Lordship. Lordship, para 7. 7 and 8 is relevant, Lordship.
Oh, that's different, Mr. Pure.
So why I wanted to show for my repetition, Lordship, at page 73.
Go back to the impugn order. What have they said? Let's see. That is quite a material. Where is that where he said that we have
156, Lordship.
that is page
156.
156.
Lordship.
Yeah, that is where they have said that. That is C.
5AB pertains to the relevant year.
5AB
5C will be for the entire service.
Yes, this is what we were concerned with.
Gotcha.
On perusal, and so read the C, 5C.
On perusal of the annual confidential reports of the petitioner from assessment year 2001 to 2022, it has been revealed that he has been graded average 2 points in the annual confidential successfully for the assessment year 2007 and 2008, while in the rank of Havaldar, general duty, and high average. Lordship, so far as these points are concerned, Lordship, these points differ from rank to rank, Lordship. These may be relevant at that time.
What relevance will they have in considering your promotion? I mean, is in your case is that it should limit only to the
promotion, the relevant 5 years.
Relevant 5 years.
Lordship.
Exactly.
Lordship.
Now these people, what they've done is they say that
they took into
from 2001 to 2022.
Lordship.
Whether they can do that or not.
They cannot do that.
Question.
They cannot do that.
Can you do it or not?
Your Lordship, in this case, this my submission is there. Your Lordship, come to this page number 134, the judgment passed by this honorable court.
No, come first to whether you can do it or not.
So, Your Lordship, as per this order of this honorable court, then it is relevant party 137, page number 137.
Yes.
Paragraph 7. This is a conclusion, but it is further provided that should the entries be upgraded in consideration of the representation taken into consideration the petitioner earlier track record, the repression authority shall constitute a review DPC for the grant of consideration relief, if any, on the basis of the above. The entire
The assumption is that you have examined it as per the track record. He doesn't deserve any upgrading. That's your case, and so it doesn't deserve. There's a question of constituting a review DPC.
So that's why you should the 2007 onward it has come up. Full test record has taken into consideration.
Then,
Lordship, for those years, I'm not even informed of what had happened at those relevant point of time. Whether I was graded 2, 5, I was not even informed, Lordship. That will be arbitrary at this stage.
But it happened a long time ago.
Lordship, that will be arbitrary at this stage if those records are taken into consideration, Lordship.
But that's not a pleading in your petition.
Lordship, kindly come to one relevant page, Lordship, to show like what was my earlier ACRI, Lordship. So kindly come to page 73. This was the affidavit filed by the respondents in the earlier round of litigation, whereby 73. They have page 73.
But Mr. Danda has a point also. The directions were such. Now they don't consider to upgrade it, so there's no question of your.
Lordship, kindly come to page 73.
DPC.
Lordship, in that column, Lordship, in the table, the relevant year 2015-16 was graded 7 points. Now following year 16-17.
7 is high average.
7 is high average.
And 5 is?
5 is average, Lordship.
5 is average?
5 is average. So, Lordship, my point is that
7, 7, 7, you got 17, 18, 7,
Lordship.
Then 18, 19, 7, 19, 27. So the assessment is wrong. So you're limiting your case this part that the non-review, you have not taken consideration the.
No, what I'm saying is, Lordship.
15 to 21.
What I'm saying, Lordship.
You have a point there. So yes.
From 7 points, I was downgraded to 5 points, Lordship. And 2015 and 2016-17, they are the same IO and same RO, Lordship. They should have,
2016.
Lordship, same. If at that relevant point of time they have graded me 5, 7, but now for this year they have graded me 5.
And subsequently, you maintain a 7.
I maintain 7.
7 till the last ACR.
Lordship. And that judgment says that, Lordship. That why I was not graded good, Lordship. Why the ACR cannot be upgraded, Lordship? Because of these reasons.
So that means we're asking for a re-examination. Is it permissible? Review of the review.
I'm asking for a direction, Your Lordship, that they should take a decision by ignoring this ACR, Your Lordship, and pass a speaking order, Your Lordship, because this is not at all a speaking order, Your Lordship.
Yes, Mr. Devnath. Have you heard the submissions?
So, Your Lordship, now
very simple. What he says is this. Now, this court earlier had passed an order saying that, fine, the ACR was not communicated, the entry is not communicated to him, so he will be supplied with the entries and he will make a representation and you will take a decision as to whether on the representation made by the petitioner the grading of 5 is to be upgraded to 7. Correct. Now what you have done, you say that no, we look at the entire service record, and so we don't. I think he's not fit for upgradation, and so promotion is disregarded. Now his case is that he is maintaining consistent 7 from 15-16 till 21, except 16-17, where same assessing officers were there. 15-16, you've given a 5. So he's saying now, in view of this, which shows that that 5 was uncalled for, my promotion should be considered by not taking into account this relevant year 16-17, and only 15-16, last 5 years, that means 17, that means 15-16 and up to 2021, disregarding 16-17. You understand?
So you will see whether it will be.
So what's your argument to that?
So you will see.
I'm putting across to you so you'll understand it.
You will see here.
Yes.
The reduction is given in the particular years.
Exactly.
So now, if you consider and generalize this other subsequent even earlier one, it was good.
The Supreme Court judgment says that if the same assessing officers had given the concerned person there a certain grade, correct? Now, same officer, without offering any opportunity to him, or whether he's been given any as to why, on what parameter he's not performed, they've downgraded this ACR to 2 points below. Now, and then the concurrent of the tribunal, that means Armed Forces Tribunal, I think, and the High Court or whatever tribunal, High Court, they said that review the gradation given in that particular year. But Supreme Court said disregard it and considers promotion only from the other years. So what do you have to say to that?
In this respect, if the petitioner is asking for this again for review, now that question will come up whether review after review will be again.
It's not review after review. He is saying that forget review of the 16-17. Forget the review. Only consider my promotion for 5 relevant years by ignoring 16-17. That means other years, if you take 5 years, you have to take 15-16 consideration. That means 16-17 you leave out. That means 15-16, 1 year. 17-18, 1 year. 18-19, 19-20, 20-21, 5 years. And in these 5 years, he scored consistent 7, which is high average.
So you will see whether in continuing these years, 1 year can be deleted.
That's why 1 year can be deleted.
So if it is, then it will be considered for the all who has been considered for the DPC.
For the all meaning? All other persons also. Then they will get similar relief then. Which will lead to cascading litigation again.
It will be giving another, there's so many aspect matters will come, the similar matter for dealing
you
this
take into account the judgment given. Just you tell the tentative view is that maybe this can be disregarded. What will be the consequences?
Possible consequences too difficult to at the moment to, because if it is happened, then ultimately subsequently again matters will come up. In this case, this is the precedent test 1 year. It was
now in other cases similar orders have been passed. There are a lot of orders passed with this court with regard to similar orders have been passed.
I am not privy to that.
Or some cases where promotion has been granted. See, there were quite a few cases, you remember, which not communicated, and then this court directed for communication for representation and for reconsideration, correct? You don't remember?
So in this case,
This is the court at least.
Lordship, so far as the petitioner is concerned, he has been promoted, but a prayer is to get to pray for retrospective promotion, Lordship. From the date that initially he should be granted promotion.
So that means he's been promoted taking from 18 onwards till this 21, 22. He's been given 7 again.
He's all right, the ACR, Lordship. Because this will affect his prospective promotion, Lordship.
He'll soon retire before he gets another promotion for sure. Yes.
Lordship, in the other matter, Lordship, where Lordship had dealt this matter in detail regarding ACR, Lordship. In that matter, Lordship, the respondents has, just before DPC, they had communicated about 10 years of ACR, Lordship.
Which matter is this?
There's one matter which your Lordship had dealt it.
With Assam Rifles only?
Assam Rifles. Yes, I have this judgment.
Can't expect us to remember everything.
This is yes, Your Lordship. This is again promotion matter, Your Lordship. And the uncommunicated was not taken into consideration, and this Honourable Court had directed the respondents to consider to grant promotion, Lordship. And all the consequential relief. In this case, they have violated the memorandum, the notification, Lordship, which requires communication, Lordship.
So you're saying now DPC is held when? That means after the communication, after a representation, and they.
No, the DPC was 21, Lordship.
No, this order is dated when?
Lordship.
When is this order rejecting? When was it passed? This impugn order.
Impugn order was passed on 30th November 23.
So
after 2 years.
That means from 30th November 23.
Lordship, because the DPC was 21st, Lordship.
21st of?
2021, Lordship. The DPC.
So then should be given benefit of 21.
Exactly, Lordship. That's my prayer, Lordship.
Yes. You're confusing Mr. Devnath Mo now.
And Lordship, the ACR endorsement by SRO is after 2 years, Lordship. This is.
That's one point also has been taken.
After 2 years, Lordship.
Yet you've taken note of the judgment. This is 2022 SC online SC 1291. You examine it. We'll let you have another chance. Yes. Although we spent enough time, only 1:30. Other matters at 2:15.
Can come back after a week, Lordship. There's some urgency, Lordship.
What is it? You're retiring?
The DPC is coming up, Lordship, in few months. After a week, Lordship.
Other hearing matters are all ready.
Item 20, if your lordships can have it tomorrow, because I have some difficulties post.
20 is what?
The golf matter, my lord. Tomorrow, my lord.
Item 19, short matter. Similar matter has been disposed of by the coordinate bench. If you can dispose of on similar lines. Yes. Regarding land compensation, direction has been passed to take recourse to section 64 concerning the same notifications. We just place the order.
What's it tomorrow, Mr. You others at 2:15 we can take it out. What's the problem?
2:15 also is fine.
Can be disposed of.
I mean, only 2 matters remain.
No, my lord, there's a mentioning matter which I mentioned that also be taken on the second half.
Your matter hasn't come also
Come now, my
to the court.
It's just we're just serving the other side now.
I'll do it tomorrow.
Tomorrow.
Even this one.
12 promoters.
Golf, my lord.
How long will you take, Mr. Nauri?
10-15 minutes.
That's all.
Maybe lesser, my lord.
Mr. Paul will reply for 1 hour tomorrow.
Yes, I have already exhausted my. Tomorrow, then, man.
So my lord, 19 also tomorrow.
Then my lord,
Mr. Deva.
then only my matter is left. If everybody is coming tomorrow at 2, tomorrow then my matter.
Then hearing.
Nineteen.
Has your file not come?
My lord, we're just serving the other side and
Okay, you'll take any chambers then. You just inform the government advocate, whoever is concerned.
yes, my lord.
Obliged.
Most obliged, my lord.